Morning, Chairperson Allen, and Councilperson Henderson, if you're still on, good morning to you as well. The staff of the Committee on the Judiciary and Public Safety. I'm Chris Geldart, the Acting Deputy Mayor for Public Safety and Justice, and I'm here to testify in support of Mayor Bowser's Second Chance Amendment Act of 2021. This bill was first introduced on November 6, 2017, and a hearing was held on December 14th, 2017. The bill was reintroduced on January 7th, 2019, and then now again on February 2nd of 2021. The modernizing our criminal record sealing laws is a racial justice and equity issue. A criminal record can have a lifetime impact on a person, reducing their ability to obtain a job, housing, or education. We believe this legislation needs to move forward this year so we can provide relief to tens of thousands of our residents. I appreciate and want to acknowledge the two related bills introduced by Council Members Trayon White and Christina Henderson. My testimony today is based on what I think is our shared belief that everyone deserves a second chance. Our current criminal record system is complicated, overly punitive, and sidelines far too many of our residents from pursuing meaningful opportunities to better their lives. It is based on an outdated worldview that assumes there is an ongoing risk posed by those who have had an interaction with the criminal justice system, even if that contact does not result in either a trial or conviction. The current system does not adequately weigh the deleterious impacts of a criminal record on a person's life. It's not grounded in recent research and literature, and perhaps most importantly, it unnecessarily creates a false choice between public safety and reentry. In fact, public safety is enhanced when we give individuals access to opportunity, and it is diminished when we put barriers that make opportunity more distant and unachievable. Each year, thousands of individuals are arrested in the district for offenses ranging from violent felonies to misdemeanors and outstanding warrants. Once arrested, each person will have a criminal record for a minimum of 2 years, even in cases where the arrest does not result in a trial, let alone a conviction. Currently, the burden is almost always on the individual to file a petition with the DC Superior Court asking a judge to allow their arrest record to be sealed. The person who must convince a judge that it is in the interest of the justice to grant their motion to seal their record. Superior Court judge has the discretion to reject the petition. While some misdemeanor convictions are eligible to be sealed, and the large majority of criminal offenses, including every felony except failure to appear, are never eligible for sealing. Additionally, there are significant waiting periods before a person is eligible to file a petition with the Superior Court. Furthermore, before a person is eligible to petition to seal an eligible misdemeanor conviction or felony, failure to appear conviction, they must be off papers for 8 years. Lastly, for convictions, the resident is limited in regard to how many convictions may be sealed, and only the most recent conviction may be sealed, effectively establishing the cap at 1. In talking about the Mayor's Second Chance Amendment Act of 2021, when examining how best to reform the system, our legislation suggests 3 approaches. First, shorten the time period a person must wait before seeking to seal their record. Second, change the level of discretion DC Superior Court judges can use when reviewing petitions to seal a record. And third, expand the types of offenses eligible for record sealing. The complexities of the DC Code require 2 different types of analysis, one for non-convictions and one for convictions. I will address these analyses, recommend a clarification for our proposed legislation, and finish with the executive opinion on B24-0110. While my office is still conducting an analysis of Councilmember Henderson's Restore Act, we look forward to working with the council on the ambitious reforms contained in all the bills. Non-conviction arrests. In cases of arrest where without conviction, district law currently places the burden on individuals to petition DC Superior Court to seal their non-conviction record. The process is time-consuming and frustrating. It must be improved. Mayor Bowser's bill would mandate the automatic sealing of non-conviction records and shorten the time frame for sealing them to 90 days, drastically shorter than the current 2 to 4 years. For individuals arrested for crimes other than those designated under DC Code as violent or dangerous, the burden to seal the record would shift from the person to the justice system. Under the mayor's bill, the DC Superior Court would seal non-conviction records within 90 days of the termination of the case. Following an order from the court, the Metropolitan Police Department would seal their records relating to the non-conviction and send a certification back to the court. The court would then notify the resident that their records were sealed. For non-convictions involving charges of violent or dangerous crimes, the person would still be eligible to seal the record after 90 days by filing a motion with the Superior Court. This process would be a significant improvement from the current waiting period of up to 4 years. The burden remains on the petitioner, however, and it allows an impartial third party, a Superior Court judge, to determine whether there is any remaining public safety value in maintaining the person's record. This provision recognizes that there will be some instances where it is in the public interest to keep a record from being sealed, but it allows for that determination to occur in a much shorter period of time. Examples of this may be individuals with repeated arrests for similar allegations, especially crimes like domestic violence, elder abuse, and sexual assault, where it may be inherently difficult to obtain the cooperation of the victim in order to propose a prosecution. Under the mayor's bill, if there was no prosecutorial objection, or if an objection is overruled by a judge, the record would be sealed. The Second Chance Acts would also retroactively benefit tens of thousands of individuals with existing non-conviction records. It would make any person with the non-conviction record eligible to file a motion to seal that record beginning 90 days from the termination of the case. Many would be eligible to seal their non-conviction records as soon as the bill was to go into effect. Now, I will discuss the approach with convictions. Research around recidivism has concluded to evolve and has continued to evolve and has expanded to trying to understand why a person recidivates. Time released from prison is one factor, but the ability of a returning citizen to have access to mental health and trauma counseling, a safe and stable place to stay, and access to employment, all in a timely manner, heavily influence whether a person recidivates. In light of this research and our policy goal of fully reintegrating returning citizens into the community, the mayor's bill would lower the number of years required to be off papers to seal an eligible conviction from 8 years to 5. Additionally, a 5-year waiting period would help bring the district closer in line with research around redemptive time. We also believe it is important to change the number of convictions an individual is eligible to seal. Current district law is overly punitive and allows only the most recent single conviction to be sealed. Our legislation would allow up to 5 convictions to be sealed. We are strongly supportive of the need to expand the offenses eligible for sealing. Current law makes every misdemeanor conviction eligible for sealing unless it has been specifically designated ineligible by DC Official Code 16-8019. Only one felony, failure to appear in court, is eligible for sealing. We support conducting a review of other felonies that should be considered eligible for record sealing, but we believe that should be done methodically based on expert research and data and accounting for the complexity of our criminal code. In our legislation, the Criminal Code Reform Commission, an independent research office, would be tasked with reviewing the district's criminal laws to identify additional offenses that should be eligible for sealing, as well as whether and how to adjust the sealing waiting times for different types of convictions. The CCRC is composed of criminal justice experts who just completed a multi-year analysis of the district's criminal laws and proposed a massive overhaul of them. We believe the CCRC is ideally suited to conduct the necessary informed review that would be required under our bill. We would like to offer one drafting adjustment to improve the clarity of the bill. We propose including the phrase crime of violence in the provisions, which allows for sealing of non-conviction records on page 4, line 83 of the mayor's bill, to go along with the phrase dangerous crime. The exclusion of this term was a drafting error, and the change should be made in order to mirror references in both types of offenses in the current DC official code. I'd now like to discuss the other council bills before us. Councilmember White's legislation, the Criminal Record Expungement Act of 2021, Bill 24-0110, would shorten the waiting period for a person to seal their eligible felony criminal record from 8 years to 2 years. The bill would expand the felony convictions eligible to be sealed to include felony theft and felony drug possession. We support the bill's objective to expand the crimes eligible for sealing and shorten waiting periods. However, we believe the better approach is through an independent expert analysis of the district's criminal code laws as proposed in our legislation. This option would allow us to move forward in a deliberate and thoughtful way. Councilmember Henderson's bill, the Record Expungement Simplification to Offer Relief and Equity Act of 2021, would rewrite Chapter 8 of Title 16 of the DC Code. While my office is still conducting a review of the bill, it would require DC Superior Court to automatically expunge all convictions for crimes that have been decriminalized and to automatically seal non-convictions, shorten waiting periods for criminal records to become eligible to be sealed, and shorten timeframes for judges, responding parties, and agencies whose certified records are sealed to respond to motions. As these bills show, there continues to be significant interest in modernizing our criminal record sealing laws. My commitment is to work with the council members on making this happen during this council period. The role of the Superior Court. As we work together in this critical issue, I must emphasize the essential role of the DC Superior Court in any efforts to modernize our record sealing process. The mayor's bill was drafted with input from the previous Superior Court Chief Judge and court staff. In our ongoing discussions with the court, they have expressed concerns over requirements enacted by council that cannot be done with the current technology and staffing. As we know, the Superior Court operates independently of the mayor and the council, with its judges appointed by the president and confirmed by the Senate. Their funding goes through federal appropriations process and exists outside the district government's budget. We must include the direct involvement of the court to ensure the legislation's intent matches the court's capacity. Otherwise, we risk enacting a law that cannot be fully implemented by the court, thereby frustrating the residents and failing to meet their needs and expectations. I'm eager to work with council members to forward these important reforms to our criminal justice system. I thank all the witnesses who testified on this important subject and appreciate their continued input into the final product. The way criminal records are created, processed, and tethered to a resident negatively impacts their chance to go to school, earn a degree or trade skill, or even be allowed to live in an apartment building. This collective impact impedes their ability to be a positive contributing resident. As the three complementary bills show, we are all pushing in the same direction. Beyond enactment of a final bill, there will be many steps needed to bring actual relief to residents. Residents will require educational outreach on the impacts of the new law. Record sealing clinics will need to be set up to connect residents to pro bono attorneys. And we will need attorneys and legal staff to help handle the caseloads. This is an issue that I believe must be approached as a partnership between the executive, the council, and the Superior Court, and advocates for reform. Finally, as a son of a convicted felon and growing up experiencing the same discrimination attested to by our public witnesses, I am committed with the mayor to working with you on this important criminal justice reform. Thank you for the opportunity to testify today, and I'm available to answer any questions.
Thank you very much.